Good morning, everybody. My name is Bruce Frew, and this morning I'm joined by my colleagues Wright and Felix Levay. And what we're doing is providing a seminar in relation to the reconsideration, and we've put it with a fairly brash title, Is It Worth It? And you'll understand why we give it that brash title by the end of our seminar. This marks the fourth seminar in a series that we started in relation to post-judgment considerations in the employment tribunal. Now, what we're going to do today is firstly start with both Felix and Connor taking you through which decisions can in actual fact be reconsidered, how the applications are made, how does the process work, and when will judgments be reconsidered. And I will highlight some examples which you'd have frequently on your mind when you are considering whether or not you should reconsider a decision at any level where you can, or you should potentially make the decision to go to the Employment Appeal Tribunal. But we'll go into more detail on that in due course. Just before I hand you over to Felix, what we really encourage is as much interaction as possible. And what we'd like you to do is ask any questions so that we can have a bit of time at the end of our talk to answer those questions and perhaps have a discussion between the three of us. Can I ask you to put any questions into the chat function as opposed to the question and answer part of this? It's the chat function to look at, and please do them as we go along. Thank you. If I could pass you over to Felix, please.
Thanks very much, Bruce. So starting at the beginning, the power to reconsider a judgment is a product of Rule 68 of the Tribunal Rules 2024. When we talk about the process, the procedure, we're going to be talking about Rules 69 to 71. The power itself is to reconsider any judgment where it is necessary in the interests of justice to do so. And before we go into any detail on process, it's important to look at that definition. It has practical implications. We know, looking at Rule 2 of the Tribunal Rules, that a judgment is defined as a decision which finally determines a claim or part of a claim regarding liability, remedy or costs, or any issue which is capable of finally disposing a claim or any part of it, and also an imposition of a financial penalty order. The reason that that is important is that, as you'll note, we're focused on the claim, not the case. So there are some pretty important decisions which are going to be excluded by that, as in case management orders, and other examples are on the slide there. So, for example, an application to strike out a response, the decision regarding that application is not something that we can make an application to reconsider regarding, even though, of course, it's very important and may well effectively bring discussion of liability to an end. Until and unless we've got a decision about the claim itself, this isn't the route we can take. And for completeness, we've just noted that obviously you do have other options when a decision can't be reconsidered. You can make an application to amend, vary or revoke an order under Rule 30. And in certain cases, obviously, you can make an appeal. And though it's not on the slide, obviously, in very simple mistakes, you can make an application under the slip rule. So what can be reconsidered? No surprises there. We've put some examples on the slide: striking out part of or of a claim, default judgment. So these are the things that we can reconsider, and we'll be looking next at how you make that application. It's a relatively simple process. You can make an application in the course of a hearing, and as we'll discuss later, that's a practical point and something to bear in mind. But let's assume you haven't made an application in the course of a hearing. What do you do then? Well, it's got to be in writing, and there's a deadline of 14 days, so it's a very quick turnaround. And that's 14 days either from the date of the you were sent the written record of the judgment, or if you've got the asked for written reasons, it'll be 14 days from when those are sent, if that's later. And while the rule itself only sets out a requirement to explain why the reconsideration is necessary, we will actually discuss that it's necessary in the interest of justice. That's the test the tribunal is going to be applying, and so that is the test that you'll need to set out, practically speaking.
Before we move on, Felix, is it worth talking about how that application process compares to that of an appeal?
Yes, I mean, there's another important practical point here, which is, as I'm sure we're all aware, a deadline for an appeal is 42 days. So comparing, obviously 14 days is a much quicker turnaround. But a really vital point to bear in mind, particularly when you are unsure initially which route to take, which is a decision we'll discuss later, is that those two deadlines operate independently. In other words, just because you've made an application for reconsideration doesn't mean those 42 days aren't running. Bear that in mind. The two deadlines operate independently. And so, having discussed basically how we make the application, Conor, I'll hand over you just to discuss the process that is then followed.
Thanks very much, Felix. The process can be broken down into two stages per Rule 70, and that's exactly what we've done here. So we've set out stage one on this slide, and we'll move on to stage two. The thrust of stage one is that the tribunal will consider, it will undertake an initial consideration on the papers. The question the tribunal will be asking itself is whether the application for reconsideration has no reasonable prospects of success, whether there is no reasonable prospect of the original decision being varied or revoked. And in those circumstances, the tribunal would refuse the application at that stage. If the tribunal doesn't consider that there's no reasonable prospect of success, then the tribunal will write to the parties, set out a deadline for the other parties to respond to the application, and indeed seek views on whether the application can be determined without a hearing. We put on the bottom of the slide there that the notice may set out the judge's provisional views, but that's not necessarily going to be the case. It's a matter for the tribunal. Moving on then to stage two, presuming, of course, that the application hasn't been refused at stage one, the decision will then be reconsidered at a hearing unless the tribunal, having regard to the responses from the parties that we spoke about under stage one, decides that a hearing is not necessary in the interests of justice. And of course, we'll be very familiar with those terms by the end of this seminar. If the reconsideration does proceed without a hearing, then the parties will, of course, be given the opportunity to make further written representations as well. There is some guidance that's provided to us, and the leading case is TW White and Sons Limited and White, which is a 2021 case of the EAT. There are 6 mandatory requirements which are very helpfully set out in that case, and we put them all on the slide there. I don't propose to go through them all because they are all set out. The real point to be taken from that case is that both at stage one and a hearing at stage two, the process should be heard by the original judge or indeed full tribunal, as the case may be. So whatever the situation was at the original hearing, that should be replicated on an application for reconsideration. We've also set out Shaw and Intellectual Property Office, which is a 2021 decision of the EAT. This is an interesting case where the question was essentially asked, to what extent can the tribunal depart from the specified procedure that's set out in the ET rules? what was said was the proceedings, the set procedure can't be cut down, but there can be some additions to it in certain circumstances. This was a case where the parties' views were sought at stage one, which of course we didn't see in the set procedure that I've just set out. The tribunal was essentially directed in Shaw that it should not normally seek other parties' views in relation to the substance of the application at stage one. But if the tribunal does do that, the applicant should be given the opportunity to make further representations. Really what the takeaway of this case is the application process for reconsideration is fairly rigid, and applicants should expect it to be followed almost as stated within the ET rules. And the next thing that I want to consider is, well, we've set out what happens if somebody makes an application to the tribunal for reconsideration. What happens if the tribunal reconsiders of its own initiative, which of course it can do? If the tribunal does decide to reconsider a decision, a judgment on its own initiative, then and perhaps it's sensible, we skip straight to the notification of the parties and asking for representations about whether or not a hearing is needed. It is worth noting, though, that while the two processes are similar, they are distinct and they can't operate simultaneously. Either the tribunal is hearing an application for reconsideration or it is reconsidering on its own initiative. Both can't be done at the same time. Another really important question that no doubt ought to be asked is what happens if a party wants to make an application for reconsideration out of time. Of course, it's not always possible to abide by strict time limits. The key point here is that there is no specific test. And we've set out on the slide there that it's not necessary for the parties to comply with the familiar extension of time tests that we would see with respect to claims. So whether or not it's not reasonably practicable to bring a claim in time, or whether it's just equitable to extend, neither of those apply in this case. It's really noteworthy that some applications have been brought successfully a really long time out of time. And there's an example known as Dean Verity and Khan Solicitors Limited, which was heard by the EAT in 2022, where there was a delay of 6 years from the original decision to reconsideration. It is important to take on board that that was an exceptional case. And of course, it was considered in the interests of justice in circumstances where somebody had been dismissed, and as a result of the circumstances as they were found, was reported to the police and the SRA. And those being the circumstances, the original tribunal decision operated as essentially a stain on the applicant's character. And in those circumstances, it was deemed just to come back for reconsideration at a much later stage. General applicants shouldn't expect to be able to bring an application for reconsideration that far out in time.
Just before you go on, in terms of your general applicant who's not going to get that 6-year extension, because people are going to be in that situation where they either had or they anticipate not being able to make an application in time. Just practically speaking, what can people do to maximise the chance of getting an application heard out of time?
Well, I think 2 points spring to mind, and that's a really interesting question. The first is essentially general principles apply. If you're making an application for extension of time, it's sensible to make that application before time has elapsed. Do so timelessly. It's much more likely to be considered in the interest of justice to extend time if you're making that application in time in the first place. Do be prompt about doing so if you can. Of course, it's not always possible, but it will, of course, be necessary to explain reasons for a later application if it is so made. A very common reason that these applications are made is because of the illness or disability of the applicant, and of course it's particularly relevant in the employment tribunal. In those circumstances, the advice that I would give is that it is important to make sure that the evidence on which the applicant relies in terms of their illness or disability is, so far as is possible, produced by someone who is appropriately qualified to give that evidence. So if there is a doctor involved, then the doctor, if someone else, I think it's important we apply our minds to who is giving that evidence as well as the evidence that is given.
I must say I completely agree with Connor there. Another example might be in cases, and I'll speak about this in a little bit more detail later on when we go to actual examples of reconsideration cases, but where you've got the availability of new evidence, for example, and I'll talk about some cases in a moment, as I say, but the availability of new evidence coming in late after 14 days doesn't really allow for the stringent test. Do we agree it's a stringent test in relation to reasonable practicability, for example, and not so stringent, but quite a difficult test often for the just and equitable test. So I think a classic example is the availability of new evidence or coming to light after the event, getting through the Ladd and Marshall test, and then being able to be used as part of the reconsideration exercise. It looks to be a fair way of dealing with things, but I completely agree that the availability of the evidence in relation to being unwell or inability to attend, whatever it may be, that has got to be seriously applied. But thank you.
Yes, thank you, Bruce. And that brings us on, I think, to the applicant has decided to make an application for reconsideration. Of course, in the respondent's shoes, there may well be a judgment that has already been entered. It's important to bear in mind that a pending reconsideration hearing, or the application at any stage, does not undermine that judgment's integrity. So unless and until a decision is made to vary or revoke that judgment, any money due under that original judgment still needs to be paid, at least in theory, if not in practice. And if it's not paid, the claimant is entitled to take enforcement action on that debt. So in those circumstances, what do we do? The practical approach to this, in my view, is reach out to the claimant if you're a respondent, let them know that you're going to be making an application for reconsideration, and that you'd like to seek their agreement that they won't take any enforcement action. I think that's the most cost-effective way and practical way of dealing with this scenario, and they may well agree to that.
Can I ask, sorry to interrupt you, Connor, when you're dealing with a litigant in person who's got a judgment in their favour and they want that money, and it could be a substantial amount of money, it's all relative often, what's the likelihood of getting that litigant in person to agree to stay or to even understand what that stay means?
Well, that's an interesting question, and I think those are circumstances that no doubt many have encountered. If the litigant in person, or indeed any claimant, is staunch about pursuing enforcement action, then the question is, well, what can the respondent do about it? Once the enforcement action is started, the respondent then can make an application to stay that enforcement action. And of course, it may well be that it can be explained that a reconsideration application has been made, and that will, of course, be the reason for the stay. The one thing to bear in mind, though, is that by either route, if enforcement action is delayed and payment isn't made, interest will continue to accrue on the judgment debt. It doesn't stop just because enforcement action hasn't been taken. The judgment debt still exists, as I've mentioned, and that's at 8% per annum, as is the case on judgments. So that's something to bear in mind.
Would we agree together, and please don't agree if you don't, that our general practical advice would be do not pay the judgment debt until after a reconsideration, or indeed it arises in the same way with an appeal to the Employment Appeal Tribunal, which can take a considerable amount of time. Don't pay that judgment debt, and if the claimant or litigant, the person, won't take advice or can't understand the meaning of a stay, for example, it's not even deliberate, let them do their worst and deal with this on that basis. Do we agree on that?
Well, yes, because otherwise you've got a situation where you've got a cause of action against them, but you've got to bring that claim, and that's going to be more money if you do actually end up getting that money back. Anyway.
Well, I think that's maybe the operative element, isn't it? They get the money, they spend it, we're never going to see it again, whatever judgment we come up with.
Exactly right. Exactly right. Felix, I think you were going to help us with now discuss the process and how it all works, what the outcome might look like.
Yeah, so the outcomes are available are what you would expect. If we've gone through the process, we've had our stage 1, we've had our stage 2, there's been a hearing or there's been a decision without a hearing. The tribunal can confirm the judgment, it can vary it, it can revoke it. If it does revoke it, it can make the decision again. What I think is worth noting is that while there is no particular limit on the tribunal's power to make variations, it would be a rare case. I think it would be unusual for to substitute a decision entirely without some sort of rehearing in a reconsideration. And once that's done, it's done. If you've got a problem with that decision, then your recourse is to an appeal to the EAT. We're going to go on in a bit to some case law looking at when reconsideration applications have been successful. Before we do, it's useful to look in the round about the difference between reconsiderations and appeals. And it is a difficult distinction. I think we all agree that it's not something that's immediately going to be obvious. So which route is appropriate? We've put on the slide there the interest of justice test. It is somewhat nebulous, and we'll look at it in more detail, but a good definition, if not one which exhaustively explains all situations, is from Trimble and Super Travel, and that is that has there been some sort of procedural mishap, some sort of procedural error that has denied a party a fair opportunity to present their case, and we contrast that with what we know are the grounds available for appeal: misdirection, misunderstanding or misapplication of a law, findings unsupported by evidence or perversity. And when we talk about misdirection, etc., regarding the law, that's a broad category, and that would extend example to a failure to give reasons. And maybe let's give an example. Let's say there's been a preliminary decision as regards disability status, or rather, let's look at a case where that decision hasn't been made, i.e., a decision needs to be made about disability status, but it hasn't been. That's more likely to be appropriate there to seek reconsideration, because the decision needed to be made and it just hasn't. We contrast that with a situation where we can see a decision has been made in the judgment, but there's no reason given for it. And I think it's fair to say that in reality, that might be very difficult to tell apart, depending if the judgment isn't very clear. So that, broadly speaking, is what separates the two. And as we go on, we'll look at the interest of justice test more thoroughly. But if that gives us a roadmap of which route will be appropriate when, well, do you want to take us through what are the practical implications if reconsideration is appropriate?
Just before you do, Connor, can I just highlight an example and also going back just to the last element of the last slide. What Felix said is that further remedy is likely to be limited to an appeal to the Employment Appeal Tribunal. So there's got to be a word of caution about that, because when you're appealing a reconsideration judgment, what you really are trying to do is appeal the initial judgment. The reconsideration has happened, it hasn't gone in your way, or they haven't even considered reconsidering. You've missed the deadline for the Employment Appeal Tribunal, and you end up appealing to the Employment Appeal Tribunal. Now, you've just explained the difficult technical scenario of the question of disability there. You put that to a litigant in person, and I'm sorry, I sound like I'm picking on litigants in person, but I do so because I've got a practical example of what could be described, certainly in my opinion, is that it's an abusive process where last October I had to go to the Employment Appeal Tribunal to hear a litigant in person saying that she had not had the result that she wanted from a reconsideration hearing. And when you talk about finality of litigation, she had no concern for that, and it had to be explained to her on a number of occasions, each time costing the respondent significant amounts of money, even if you got a costs award, and we did for the Employment Tribunal element, never been paid as far as I'm aware. You're never going to see that money. So the difficulty is that whether or not we advise properly, what you may be the subject of is a litigant in person effectively abusing a process where they end up with a costly to us, if you're for the respondent, explanation at the Employment Appeal Tribunal. Indeed, my understanding is that the same person that I was before His Honour Judge Beard in October on has made an application to the Court of Appeal. So there you are. So forgive me for interrupting, but I just wanted to highlight that you have to be careful not to lose your patience with the ability for litigants in person to abuse this element. Lots of elements in the Employment Tribunal that they can, but we're talking about reconsideration today, and so I focus on that. Thanks, Connor.
Well, Bruce, that brings us on to a really interesting point, which is, that's of course the cost of opposing the application or appeal. What's the cost of making the application or appeal? Thinking about that, we've set some points down on the slide there, and that really is the gist of what I'm about to say, but I will add some meat to the bones. The cost overall of a reconsideration application is likely to be much lower than that of an appeal. And I think that's fairly uncontroversial to say. The process that we've heard about on reconsideration is first that an application has been made. That may, of course, not be the case, but let's assume that an application is being made on paper in the form that we've heard. The application may well be refused at that stage, and that's an end of the matter. Of course, relatively efficient way of dealing with the application. The application may then go off to be dealt with without a hearing, subject to the tribunal's view and indeed the responses of the parties at the initial stage. And again, regardless of outcome, that is an end of that process, and therefore, again, being very efficient and not having to go to a hearing. Even if it does go to a hearing, though, the hearing is likely to be much shorter than an appeal hearing, including but not limited to the fact that the original judge or tribunal will be hearing that application. And so, bearing in mind all of those things, and indeed the opportunity for the application to come to an end at an earlier stage than perhaps envisaged, either successfully or otherwise, it does mean that the costs are much lower in the round. The process also is generally much shorter. Of course, the deadline for making an application for reconsideration is 14 days. It does bring to mind, though, the interplay between appeals and the reconsideration process because of that short deadline. Bruce, do you have any thoughts about that?
Well, this is the stage where you're advised, you receive a judgment. Of course, you can make an application for reconsideration once you've received the oral judgment, okay? And that would be a cost-efficient way of doing things. And in actual fact, I did that recently. I was in Bristol at the beginning of the year on a remedy hearing, and I'd made a point about remedy based on case law. And my view was that the judge had misinterpreted the case law, and it was a mistake that led to an element of the judgment being wrong. Now, whether that had any overall effect was a moot point. But what I did do is raise it with the judge and say, look, Judge, I think on the basis I've heard your judgment, thank you very much. I think I'm going to ask you to reconsider this element for these reasons. And on that sort of informal basis, the judge did ask me to confirm whether I was making an application for reconsideration. He was happy to hear it, albeit it was late on a Friday afternoon. I was very grateful that he was happy to hear it. And he made a decision based upon what I considered to be an element in the interest of justice, even just to give finality to it, so that we didn't have to go away, think about it, make an application, and all of the associated costs to it. Now, that aside, when you receive a written judgment, the full written reasons, that's the time where I'm often asked to advise on, should we go for the Employment Appeal Tribunal, should we go for reconsideration, or should we do both? And what must be borne in mind, and it's often conflated, is that these are two totally different forums. And Felix is going to tell us what the interest of justice actually means. It's a whole other seminar to talk about the grounds of appeal to the Employment Appeal Tribunal, but it must be borne in mind that these are two totally different forums, two totally different approaches, where they are regrettably conflated, and it's often our job just to separate those out on a basis which is well understood, so that we don't spend money in one direction when it's simply unnecessary. And if I hand over to you, Felix.
Yes, before we do, yes, just a really interesting point you raised there, Bruce, about what happens when judgment is handed down at a hearing. Indeed, if we were to take Felix's lovely example of disability not being considered by the tribunal where it was necessary to do so, if we imagine we're in a situation where that judgment is being handed down, it's, I think, really important to raise that the representative of a party can raise that application, exactly as you say, at the hearing while the judgment is being handed down. And so the representative can deal with that application, the tribunal can deal with that application, and a decision can be made without any of the steps that we talked about. It can be done at that hearing at no extra cost, because, of course, that party is already in attendance. And indeed, that keeps the costs very low indeed, in fact, to next to nil. And that's something that a respondent, I think, can really do to assist the situation in that moment.
It's absorbed by the brief fee on that day, isn't it? And the solicitor's costs. And well, a practical element to take away, perhaps, is that whilst we're taking a judgment, it can look like we're doing nothing. But constantly, you're like a coiled spring looking to see if, and I'll go through the examples in a moment, you're knocking off the examples to see, is there anything that the judge has just said which I can attack if it looks like it's not going in my direction? Can I, either for the purposes of today's talk, is there something that I can raise as a reconsideration point which will have a material effect on the judgment? That's important, obviously. Or is there something that we can take to the Employment Appeal Tribunal and make a careful note of it to advise on at a later date, obviously within the 42 days, not working days. It's an important point on the limitation, not working days. So you have a coiled spring like that, but also it's the responsibility of solicitors as well, in my mind, to be thinking in that same way, or indeed, it's speaking to your barrister before judgment and saying, will you have it in mind that you could raise a reconsideration point today, or will you be considering whether or not we have grounds for appeal to consider in the future? I would raise that with your barrister if they haven't discussed that with you already. So there you are.
Yeah. Well, I mean, I think that's a useful way of framing the next slide. I'll just take us back there, because what are you looking for, as you say, particularly for example, there might be a preliminary issue that's being determined, and you want to look at the way that decision has been made. A useful background to the interest of justice test, and I think this explains the sort of thing you might be looking for, is that it used to be the case under the 2004 tribunal rules. There was a specific list of situations in which it would be appropriate to make an application for reconsideration. You can see them on the board. These reasons are no longer provided by what is now Rule 68. It's just necessary in the interest of justice. However, the reason I've included this here is because when we look at these, these situations are going to crop up a lot of the time when we talk about what's in the interest of justice. And Bruce is going to talk about some case law later on, and we will see that these are included. What is the interest of justice test itself? We've already looked at the case of Trimble, which is as close to a definition, I think, as we get, which is there's some sort of procedural mishap. It means a party doesn't have a fair opportunity to present their argument on a point of substance. There's some overarching factors that are going to be taken into account. Obviously, any decision the tribunal makes will seek to give effect to the overriding objective, and that's particularly relevant in this case. A point that was made in the case of Phipps is that the balance of prejudice is relevant. The point being that it's that the balance of prejudice also includes the prejudice to the other party, because obviously they think a decision has been made. And particularly, Connor's given an example of 6 years later, they find out no, it hasn't been made. Any money might have been spent, and you've got to deal with the fallout. And that takes us to Newcastle upon Tyne City Council and Marsden. And it's an individual case, but the general proposition runs through all law, which is that there is an importance of finality. There's a public interest in decisions being made and everybody understanding that is what has happened. So it's not a power that's going to be exercised too readily. And lastly, I could put a word of warning and something to bear in mind. Ebury Partners, this isn't an opportunity to have a go at the original decision. You may not like the original decision. You may think it's a bad decision. But what we're looking at is this interest of justice. Is this has someone had a chance to make that case properly? It's not about you think the decision should have been made in a different way. All things to bear in mind at an overview level. And I'll hand over to Bruce now, because he'll take us through some individual cases which will help us flesh out in practice what this looks like.
Thank you, Felix. So just picking up on a couple of things from that last slide that's been provided and Felix has gone through, you have to bear in mind that a great deal of the case law examples are pre-2004. Indeed, I think each of them that I refer to is pre-2004. And what you want to consider, if a judge, I've had judges say where there's perfectly good case law, UCAT and Brain was the last one, that's about following a reasonable managerial decision. The judge says, well, that's a case from the 70s. How can you possibly be referring to that? But it's good case law. So if you're approached by a judge and identifying, look, the interest of justice is the test, why are you referring to old cases? Well, you maybe want to rely upon its Ministry of Justice in Burton, 2016 case, where the Court of Appeal commented that the earlier case law cannot be ignored. It should, however, be noted that the grounds on which the party could apply for a review were different. Okay, so you can identify that to a judge who's being not tricky, but just stating a point that they need to be satisfied on. That case law will satisfy it. So let's have a look at, firstly, an administrative error resulted in a wrong decision. I'm going to go through each of the examples, save for in the interest of justice, because that'll be a repetition of what Felix has just taken us through. So the case of Sodexo is a good example where what we've got is the Employment Appeal Tribunal holding that the administrative error included errors by the parties as well as by the tribunal staff. But bear in mind, it's not an administrative error by the, at the time, the employment judges were referred to as chairman, an employment judge, as they were then known. But it was necessary for the party seeking a review to show that the administrative error had led to the wrong decision being made. So you can identify an administrative error. There's frequently a date that's wrong in a judgment that's given, but does that actually affect the final judgment? Does it lead to a wrong decision? Of course it, well, not of course it doesn't, but often it doesn't, but that's the operative element of it. Now, when I said earlier, your barrister should be like a coiled spring in listening to the judgment, looking for an opportunity to seek reconsideration or indeed grounds of appeal. Connor, you've got an example recently where you were at a remedy, not a remedy, prior to remedy.
Yes.
Where you were at that coiled spring, I suppose.
Well, so this was a hearing where we attended for, of course, the initial hearing, and judgment was put off to be handed down in writing, and not related to particularly administrative error, but it is a relevant thought. This was a judgment where there were issues about Polkey and remedy that were discussed in the initial hearing, as one would expect, and substantial submissions were made by me on that point. Judge came back and said, well, I didn't hear submissions on it at all, which of course wasn't right, and took me very much by surprise, having read the judgment. The consideration was then, well, what do we do? Do we apply for reconsideration? Do we appeal? Bear in mind that it's one of those cases that perhaps straddles the line a little bit between a decision not being made and a decision having been made, but that decision being that the tribunal didn't hear submissions on it. And so that was something that was playing through my mind. But what the judge also did was send the hearing off, send the matter off for a remedy hearing. And so it seems to me that the most practical way of dealing with it was simply to deal with it at the remedy hearing. And that was, I think, the most effective way of going about it.
Thank you, Connor. There was a pause there because our screen went blank for a bit. Hopefully it's back on. Now, moving on, another example is where you receive, well, there's a notice of hearing at which the decision was made wasn't received. And we can look at the case of TD Transport in Portsmouth against Limburn. It's a difficult ground on which to rely, as the burden was on the party alleging that they did not receive the notice of hearing to prove this. And you frequently see this sort of approach in the employment tribunal and, of course, other jurisdictions where there's a mistake made because a post wasn't received. But the usual checks are gone through. Is this your address? Where you were in? All those types of things. But the burden, as I say, is on the person alleging that they didn't receive the notice of hearing. And it's a high burden because there's regrettably scope for people to be incredible on that basis. Now, next example, decisions made in the absence of the party. A party had to have good reason for their absence from a hearing if they want to rely upon this ground. I've got two examples for you on this, where the applications on this ground were successful. So the first one is Morris and Griffiths. What happened is that a respondent had fallen ill on their way to the tribunal and had to go home. Again, going back to what Connor was saying about the strength of medical evidence that you need, I suspect you would need it for that. as well. At every stage, you need to be careful with that. And then the second case is the Lawton and British Railways Board. So bearing in mind these are 77 and 80, very old cases. What's happened in Lawton is that a litigant in person had made a genuine mistake and missed the first day of a hearing, attending instead on the following day. They were successful. Now, a case which I don't think is on there, it's GMB, a GMB Service Limited case, it's 1992. What's happened in that case is that the respondent failed to attend a hearing, believing that it had been postponed, and the Employment Appeal Tribunal went on to uphold the employment judge's decision to refuse the review. The respondent's representative had been careless in not checking that the application for a postponement had been received and approved. So that careless element stopped it going ahead. Now, I think one of the biggest elements is, and potentially really useful use of a reconsideration hearing, is in relation to the availability of new evidence. And to succeed on this ground, the paying party making the application needed to be able to show that the new evidence, firstly, could not have been obtained with reasonable diligence for use at the original tribunal hearing. Secondly, was relevant and would probably have had an important influence on the hearing and was apparently credible. So that all makes complete sense to me. And it comes from Ladd and Marshall, which is, we're going way back to 1954, but that's the case. It's always cited as the first instance, the first stance to take, I think, when you're dealing with new evidence. Now, I've got some examples of where cases where the availability of new evidence led to a review. And again, I say that these are really useful, potentially. The case of St. Andrew's, Catholic Primary School in Blundell, 2011. This is where the employer obtained evidence that called into question the basis upon which the tribunal had made a large award for future loss of earnings. And the other case is Qureshi and Burnley Borough Council, where a successful claimant subsequently admitted to his employer that he had lied on oath when giving evidence to the tribunal. Now that's one scene, if you look at the Ladd and Marshall elements, was apparently credible, was relevant and would probably have had an important influence on the hearing. Well, that gets a tick. The difficulty is with the credibility. I mean, the employee could, I suppose, run all sorts of arguments, couldn't they? Like, I was making it up, I was showing off, of course I didn't mislead the tribunal, those types of things. But in that case, it was successful. The final case on this element of examples that I'll refer to is it's Meteor Parking Limited, 2009 case, where Lord Justice Underhill at the time said he accepted that fresh evidence may come to light only after the deadline to apply for a review had passed, and held that it would not normally be just for a tribunal to refuse to grant an extension of time in such a case. And that goes right back to, I think it was you, Connor, talking about the reasonable practicability test, the just and equitable test not being employed. And this is a perfect example of where Lord Justice Underhill identified it wouldn't be fair, it wouldn't be just not to grant that extension. And of course, this new evidence is going to come. It's got to come sometime after the judgment, and presumably well after the 14-day period. So there you have it. Next example, and I appreciate we're at 20 past, so we're going to canter through this. The failure to present or deal with the case properly. I've referred to the case of where are we? So failure of representation. Yeah. So the case I'd really like to concentrate on that you've got examples there that in actual fact Felix had cited earlier. But if you look at the case of Trimble, as I'll just give one example of this, a tribunal held that Ms. Trimble had been unfairly dismissed, but without hearing her representative on the question of compensation, went on to hold that she had failed to mitigate her loss and so would receive no compensatory award. The tribunal refused Ms. Trimble's application for a review, suggesting it involved a point of law that should be the subject of an appeal, and the Employment Appeal Tribunal held that where, due to an oversight or procedural occurrence, a party was not given a fair opportunity to present their argument on a point of substance, such a procedural shortcoming could correctly be dealt with by a review. Now, I did want to speak about a bit about the Lindsay and Ironside Ray case, but I'm not going to because we're running out of time. What I do want to move on to, though, are events occurring after a hearing.
Yeah, we've got that.
Yeah, you've got it. Thank you. So events, what we've got are, if we have a look at Help the Aged, there was a 60-year-old claimant was being awarded compensation on the basis that they were unlikely to find another job, but in fact found further employment 2 weeks later. Again, a really useful to tap into that proposition if you find out that extra evidence, and it goes into the Ladd and Marshall element as well. And then we've got a case where a tribunal held that an employee had been unfairly dismissed when their employer dismissed them without an investigation on discovering that they had been charged with production and possession of cannabis, but the employee was then subsequently convicted of the offences. What happened, and this is the case of Laddup and Barnes, the Employment Appeal Tribunal overturned the decision and substituted a finding that the employee had contributed 100% to their dismissal. So the really useful approach to cases. Now, if I just for a moment go back, if we've got a little bit of time, to the, and I say maybe just me, but the availability of new evidence is a particular interest to me and goes into the cases which I've just mentioned. Felix, you've done quite a lot of research on this area, and you had an observation, anecdotal, but an observation.
Well, I just think we've talked a lot about case law and the broad principles, and obviously that is useful. But I think it's also useful just to think about statistics and practical experience. If you're looking at judgments coming out of the Employment Tribunal on gov.uk, if you pick any sizable sample, then you'll find that the single most popular, the single reason of the number that we've discussed would be availability of new evidence. And that's because, as you say, it's easier to argue, and also because it is naturally one that is going to be used when you are considerably out of time to make an application for consideration. So I mean, I think that's one point to make, and also a word of caution and why we think it is important to stress the interest of justice test. The vast majority of applications for reconsider fail either immediately at stage 1 or at stage 2. I think that is useful context for any discussion about this.
I think it's got to be right. And what happens is it's misunderstood as a second bite of the cherry when it's absolutely not, and regrettably can be the subject of abuse. Now, that takes us to an end, at the end of our talk. What we've asked you to do is ask any questions, and we've now ran over time, so forgive us for that. Perhaps forgive me. I think it's maybe my fault. Now, do we have any questions, Connor, that we could?
We do indeed. Ram has asked a really interesting question, and they say, can you request the ET to reconsider a dismissed case where a lay representative withdrew the claimant's case without the claimant's knowledge or authority? The ET dismissed the case after receiving the withdrawal letter. If nothing else, I wonder, before I ask you that, Bruce, whether it might be worth going back to slide 24, because I think that might have already given us some of an answer. But Bruce, do you have any thoughts about that?
I'm not sure I follow just how badly wrong that case has gone, but it definitely falls into the failure of representation, and it looks like it's not going to get you through a reconsideration.
Yes, absolutely. I think that's everything that's in the chat. I will double check just to make sure that nothing's made its way into the Q&A. if anyone does want to ask anything further, by all means, raise questions in the chat now, and I'll try and keep an eye out for those.
Well, if that's the end of the questions, thank you very much for attending, and please enjoy the rest of your day.
Oh, there is one. There's
okay.
one that's made it into the Q&A. Why were the specific interests of justice grounds in Rule 34 of the 2004 version of the ET rules removed?
Well, I suppose it's to simplify it, but also removed is maybe the wrong way to describe it. They still apply. They're just what did removed from our talk? Maybe I don't know.
No. So I mean, I'll just go up actually because I think that's a useful. That's an interesting question, and it helps delineate what we're talking about.
Yes.
Under the 2004 rules, there were specific scenarios
yes.
that were applicable. I think the question is, well, why did we go to one test? And I think the interest of justice test was there in the beginning, but it was a residual. It was the anything else category. It was a miss category. And I don't know, but I would presume that the test as it now stands incorporates all of those.
Well, it does. That's why I say to say it's been removed is technically correct. It absolutely has. But all of the considerations on the slide before us are still considerations made before the Employment Tribunal on the question.
And of course, the point is that if you move away from having interest of justice being the residual option, it makes clear that it's a slightly broader.
Agreed.
Broader than just this list plus anything else.
Yeah.
It's making it clear that there will be situations which aren't listed here.
Yeah. So it assists. So it's a broaden, as you say.
We do have a further response from Ram. Thank you, Ram, for coming back to us. I understand that what you're saying there is that the EAT has suggested to the ET that it should be a matter for reconsideration. This might be one of those cases where it needs a bit of a deeper dive, I think, and perhaps it might be a case on which you'd like to reach out to us after this seminar. By all means, get in contact with us via the clerks. We'd be happy to have a look in more detail and consider that further with you.
Yeah, I think that's sensible because I must admit I didn't. It's quite a complicated set of facts and highly unusual by the sounds of it. So Ram, do contact us, please, if you've got a moment, and we'll go through it in detail.
Absolutely. Lovely. Well, I think that's everything in the chat box, and in those circumstances, I think it leaves us only to say thank you for attending.
Yeah, thank you very much.
Thanks very
Good
much.
morning. Enjoy the rest of your day.